Hi, my name's Caroline.
And my name's Christian, and for our case, we have Schenck versus the U.S. It was argued on January 9th and 10th of 1919, and it was decided on March 3rd of 1919. So some of the background information we found was that the appellant was Charles Schenck. He was the General Secretary of the Socialist Party, which opposed the military draft, and him and his party administered leaflets out to citizens in the U.S., which encouraged people who had been drafted to resist the draft and go against it. The appellee was the United States, and the advocates for the case was Henry John Nelson, and he was for the plaintiffs in error. John Lord O'Brien was for the defendant in error, and Henry J. Gibbons was also for the plaintiffs in error.
So the constitutional provision in question or the issue involved was the First Amendment right of free speech, which was at the time was at odds with the safety of the people during war. And Schenck argued that the Espionage Act was unconstitutional and he was using his First Amendment right.
So for our hypothesis that we came up with, it's that the court will either prioritize the First Amendment, allowing Schenck to endorse the resistance of the military draft and contradict the Espionage Act, or it will follow the precedent established by the Espionage Act and the U.S. would win.
And the actual decision was that the freedom of speech protection afforded in the U.S. Constitution's First Amendment could be restricted if the words spoken or printed represented to society a clear or present danger. And essentially, it meant that the freedom of speech or print can be limited if what you're saying can intentionally or unintentionally harm the United States. And he was convicted with conspiracy to violate the Espionage Act of 1917.
Reasoning and analysis is that the precedent from the 1917 Espionage Act, it made it illegal to interfere with negatively with the war during wartime, and it relates to Schenck versus the U.S. because they're both about the rights being restricted when in war. It couldn't promote the success of the enemy, and the majority opinion of Oliver W. Holmes Jr. stated that the free speech clause of the First Amendment does not shield advocacy urging conduct deemed unlawful under the Espionage Act.
And the impact of this ruling was that it took away some of the people's rights in certain extreme cases, such as wartime, in an attempt to protect the many. Holmes also stated that words which would be within the freedom of speech protected by the First Amendment could be subject to prohibition if it was to create a clear and present danger.
So a similar case that we had found to this one was Gitlow versus New York, and Gitlow had been convicted for writing a manifesto describing and advocating for overthrowing the government and the U.S. government. And while it wasn't an immediate danger to the government, the U.S. still was threatened by it, and he was convicted.
And these are our sources.